In 1880s American records, one woman's name appears again and again. She was enslaved. Dozens of children are listed under her name, but every record leaves the father blank. This was not an error, it was a system, until one judge refused to ignore the silence. In the early 1880s, county courthouses across the American South remained filled with ledgers that predated the Civil War. Bound in cracked leather, stained by damp air and handling, these volumes contained birth registers, probate records, labor contracts, and property inventories. Many had been written decades earlier, yet they continued to govern lives well after emancipation. In one such courthouse, historians later noted an irregularity that was not immediately remarkable to clerks of the time. It appeared only when the same name was encountered repeatedly across separate birth entries. The record showed a black woman, formerly enslaved, listed as the mother of numerous children. The entries spanned years that crossed from the final decades of slavery into the early Reconstruction aftermath. What distinguished these records was not the number of children alone. Large families were common among enslaved populations due to forced reproduction and the absence of reproductive autonomy. The irregularity lay elsewhere. In each entry, the line designated for the father was left blank. 19th-century county birth registers typically named a father when known, even under slavery. When paternity was uncertain, clerks often wrote unknown, colored, or listed an enslaved man from the same plantation. In rare cases, the space was deliberately left empty. Historians note that such omissions were not accidental, they were administrative silences. By the early 1880s, clerks reviewing older records for taxation, inheritance, or census reconciliation noticed that this particular woman's children, numbering well beyond 10, were all recorded without paternal attribution. The repetition stood out amid otherwise routine paperwork. Archived marginal notes from the period indicate that a question was eventually raised during a property dispute involving descendants of a former slaveholding estate. Probate records required verification of lineage. When officials attempted to trace paternal connections, the records provided none. This absence mattered. Antebellum law, a child inherited the legal status of the mother. After emancipation, lineage affected labor contracts, apprenticeship rulings, and claims for support. The missing paternal names complicated these proceedings. Contemporary county correspondence suggests that the matter was referred to a circuit judge for review, not as a moral inquiry, but as a bureaucratic problem. The law required clarification. The paperwork did not provide it. The judge, whose docket included land disputes, vagrancy cases, and contract enforcement, encountered the records as part of routine judicial oversight. Yet unlike clerks before him, he did not dismiss the omission as standard practice. Surviving judicial notes from the period show that he requested additional files, plantation birth logs, estate inventories, and pre-war medical records kept by local physicians. This action was unusual. Judges in the 1880s rarely scrutinized the private conduct of former slaveholding families unless compelled by financial or jurisdictional necessity. But the records compelled attention by their accumulation. Dozens of births. One woman. No father ever named. The judge did not record speculation. He did not make accusations, but he ordered a comparison of dates, locations, and ownership records associated with the woman during her childbearing years. What emerged was not a single incident, but a pattern consistent with what 19th-century observers, abolitionist accounts, and post-war testimony had long described but rarely formalized in court. The systematic sexual exploitation of enslaved women, shielded by law and custom and preserved in silence by official record-keeping. This was not discovery in the modern sense. The reality was widely understood, but it was rarely acknowledged within legal documentation. The difference here was procedural attention. The judge treated absence as evidence. By the standards of the 1880s, this constituted an intervention. By the 1880s, slavery had been legally abolished for nearly 2 decades, yet the social order it created remained deeply embedded. Formerly enslaved women lived under systems that continued to regulate their labor, mobility, and family life through debt peonage, apprenticeship laws, and racialized policing. Historical census data from the 1880 and 1890 enumerations show that black women were disproportionately recorded as heads of households, often without legally recognized spouses. This was not evidence of absence, but of systemic erasure. Enslaved unions had rarely been formalized. Post-war marriage registration lagged, particularly in rural counties. Medical reports from the Freedmen's Bureau and county health officers documented high maternal mortality, frequent childbirth, and long-term physical trauma among formerly enslaved women. These reports, written in detached medical language, nonetheless describe bodies worn by repeated pregnancies beginning in adolescence. Plantation records from the late antebellum period confirm that enslaved women were frequently relocated between estates. Birth logs followed ownership, not family. Paternity, particularly when involving white men, was intentionally omitted. Such omissions protected property holders from legal or social consequence. By the 1880s, these practices were no longer legal imperatives, but they persisted as habits of record-keeping. County clerks often copied older entries verbatim when reconstructing registers lost to war or decay. Silence was preserved. Judges in this era were not agents of reform. Their role was to stabilize property relations in a society unsettled by emancipation. Intervention occurred only when silence disrupted administration. The social order discouraged inquiry. White authority remained dominant. Black testimony was frequently discounted or excluded. Courts relied on documents produced by the very systems under question. Within this structure, the absence of a father's name across dozens of entries was not interpreted as scandal, it was interpreted as convenience. That the judge chose to examine it at all reflects not moral awakening, but procedural disruption. The system turned, briefly, on itself. The woman at the center of the records appears only in fragments. Census schedules list her age approximately, her occupation as laborer or domestic, her children enumerated without paternal names. She is not quoted. She does not testify. The judge appears in docket summaries, correspondence, and marginal notes. He is not recorded as condemning individuals. His intervention is procedural: requests, comparisons, inquiries. Estate records from the former slaveholding family show multiple male heirs managing property during the woman's childbearing years. Medical logs list treatments for childbirth. None named fathers. Local newspapers of the early 1880s reported briefly on an irregular probate matter, without elaboration. Such euphemisms were common. The escalation was quiet. No arrests, no indictments, only a judicial acknowledgement that the omissions were systematic, not incidental. The documents reveal no confession. They reveal structure. Historians note that silence itself functioned as evidence. Medical reports acknowledge repeated childbirth. Legal records omit fathers. Census data shows fractured households. Institutional silence was not failure. It was design. The judge's ruling did not assign guilt. It did not name perpetrators. It merely recognized that the omissions had legal consequence. This recognition entered the record. That was the intervention. No punishment followed. No restitution. The woman continued her life in obscurity. Her children dispersed through labor systems. Yet historians note the significance. A moment when silence was noted as deliberate. The legacy is not justice, but documentation. The record holds absence as testimony.